Okay, so just so I understand your evidence, your evidence is that ASIC has a role in the prospectus, but it can't be expected to know everything, so that's got to be reasonable about that. But then I guess my question is, ASIC has strong laws that can support it taking action if there is a defective prospectus. And what does it say, again, to the market that a likely defective prospectus here has not been the subject of any regulatory action?
I think it sends a message that you can get away with things. And it's not the first time. I'm aware of other cases where there have been forecasts in prospectuses, and I'm thinking about it goes back some decade when toll roads were first being financed and prospectuses issued in relation to the raising of money for toll roads, where the whole economics of the investment was based on traffic forecasts, and a number of those forecasts were found to be wanting. Litigation did result, and there may have been a measure of compensation paid to the affected parties, but again, ASIC was not visible in taking action, and if you don't take action as a regulator, then it's like the police not enforcing police limits. People will think they can get away with it.
ASIC finds that the prospectus did include both general and specific disclosures of risks and assumptions used in formulating the revenue forecast, which provided sufficient guidance to users about the presence of risk factors, etc., etc. What do you make of that? What do you make of that assessment?
Well, again, I can repeat what I said earlier, that we're being asked to trust ASIC that there was insufficient evidence when it really hasn't explained, and I realise there may be good reasons not to divulge sources or information, but it just beggars belief that a company can face such grand grades so quickly after a listing. And to me, it smacks of something being primed or pumped up. Money changes hands, and then the people who bought in are left holding the baby. It just beggars belief that there is no evidence, and indeed there was a very, as these disclaimers go, a very strong disclaimer that really exculpated or sought to exculpate the company and its officers really from any wrongdoing in relation to the numbers, and we specifically drew that to ASIC's attention in the letters we wrote in that exposure period. So again, there's something wrong with the system then if a company can produce a 330-page prospectus, closely typed, and use that to get away with such a bad result for the investors. And so if the law is insufficient, then I would say that ASIC needs to be articulating what it needs what additional powers it needs, or what additional changes are needed to ensure that these things don't happen again.
ASIC have said on the insider trading matter that they will not be pursuing anything here, and they've closed that investigation because they couldn't stack it up. Now, in your experience, if two people are wanting to engage in insider trading, do they send text messages that say, "Dear Mark, please find enclosed my plan to engage in insider trading. Regards, Andrew"?
No, they wouldn't. It would be done surreptitiously, and I've not actually participated in a prosecution, but I've obviously read about those, and ASIC has from time to time been successful. And clearly ASIC is probably correct in saying they don't want to reveal their modus operandi, but I would have thought this is a clear case given the proximity of the sale, the relationship between two blood relatives living together, and I know it's a principle that would not apply in criminal law, but in the law of negligence, the facts speak for themselves. And I think ASIC as a litigator, professional litigator, someone whose business involves litigation, more should have been done, and I think could have been done. And sometimes it might just require action to be taken, even if the advice is there's not a guaranteed chance of success, because I think it's being seen to be upholding and applying and requiring others to apply or comply with the law that matters.
So, in your experience of working with whistleblowers, I mean, why would anyone bother to do this in Australia?
I do not know. I've only really, most of my experience has been with the Newark's whistleblower, but I obviously read and heard stories about those that have led to the Banking Royal Commission, for example, and it really means that you are put out into the cold and ostracised by those that you formerly worked with. You've sort of excluded, if you like, from that corporate club.
Yeah, I guess I'm asking more in the sense of why would anyone go to ASIC given the way that people are treated?
Well, I don't think, and certainly if someone came to me and said, should I report this to ASIC, I would be advising them not to, because over the period of time that we engaged with ASIC, not even acknowledging the receipt of our first letter, for example, I think demonstrated that they really didn't regard whistleblowers as an integral part of their business,